China Report.
Six-minute round, and I would ask Mr. Genuis to proceed.
Well, thank you very much, Mr. Chair. And before I get into questions to our excellent witnesses, I just want a couple quick housekeeping things. I want to give other committee members notice of a motion, quote, that this committee prepare a report on the situation in Hong Kong to be tabled as soon as possible following the completion of hearings looking specifically at the situation in Hong Kong. So that's a notice of motion. I'm not moving it at this time. And I also want to just suggest to you, Mr. Chair, that in light of that notice of motion and a motion that we previously adjourned debate on, that we consider scheduling 20 to 30 minutes to discuss these motions after the witnesses at the end of Monday's meeting. So I'll put that out there for your consideration, the consideration of other members. And now to my questions to the witnesses, thank you for your excellent testimony. It's important that we hear that Magnitsky sanctions is a reoccurring theme, not only in these hearings on Hong Kong, but really across the board. I really appreciated Mr. Rogers' clear statement that the Chinese regime does not respond to statements or rhetoric, that they respond to pressure. And I want to also just single out Mr. Kwan's comments on nuke tech. I think they're so important. That we take a look at what happened here from the government on this nuke tech issue, because given what we're finding out now, it looks like this is either historic stupidity, explicit corruption, or maybe someone here getting caught in some kind of honey trap. It's just so bizarre. It's so hard to explain any other way, and I think we really need to get to the bottom of that. So thank you, Mr. Kwan, for your comments on that. I wanted to drill further now into the immigration, the lifeboat questions, with questions for Ms. Go and Mr. Rogers. So, in the opposition, we've been calling on the government to have and to articulate a plan for helping Canadians who want to leave Hong Kong be able to leave Hong Kong. Because I'm quite concerned that the government of China could take action against Canadians living in Hong Kong. Canadians are well aware of the case of Michael Kovrig and Michael Spavor, but one of our witnesses at the last meeting referred to the possibility of, quote, thousands of Michaels being used against Canada, really the escalation of hostage diplomacy on a mass scale if there are efforts to prevent Canadian citizens of other countries, and human rights defenders who might want to claim asylum from being able to leave Hong Kong. And I think we've already seen efforts by the Chinese government to make it more difficult for British nationals to leave in response to the schemes put forward by the British government. So maybe Mr. Rogers, you first. What efforts are we seeing by the Chinese government to prevent foreign nationals from leaving, and what should Canada do to plan for that scenario and be prepared to ensure the security of our citizens?
Well, thank you very much for that very important question. So far, what we have seen is mostly threats by the Chinese government. I'm not aware of concrete steps yet, but certainly the threat to not recognize the British National Overseas Passport, and so that obviously could cause complications for people leaving Hong Kong. So far, a number of people have been able to leave and have come to the UK. I think in the last, since the security law was introduced, at least 60 people, maybe more by now, are in the UK. But there is that threat not to recognize the BNO passport. Of course, there's all sorts of threats against British interests, British companies. They're fairly general threats at the moment. But I think we should brace ourselves for those repercussions. But that is all the more reason why we should be, your country and my country should be trying to help our citizens get out now while they still can.
Thank you very much. So we're seeing threats around the prevention of people leaving, and it seems like that's a real risk of this kind of hostage diplomacy accelerating and growing to include more people. And I see you nodding, Mr. Rogers. So thank you for that. Ms. Go, do you want to weigh in on the same question about in terms of a lifeboat scheme, what is the likelihood of the Chinese government trying to make it more difficult for us to help people in Hong Kong get out, and what kind of countermeasures should the government be prepared to take?
Right. So for now, if you're a Canadian citizen, chances are you still will be able to get out. But the problem is there are many, for instance, there are some legislative council members in Hong Kong who gave up their Canadian citizenship status in order to run for election. So I'm not sure how the Canadian government will whether or not we will regard them as Canadian citizens anymore is a question. And also, even if they are Canadian citizens, they may have family members who are not either permanent residents or citizens of Hong Kong. So they may not choose to leave at this point, and it may become more difficult for them to leave in the future. My other concern is that Canada may start to impose visa requirements on people from Hong Kong as well, right? So let's say if you're a Canadian citizen living in Hong Kong, but you have family members in Hong Kong, you want to bring them with you to Canada, they may or may not be able to do so unless we have some requirements to allow them. And right now, there's also, on top of everything else, travel ban. So unless you have family members who are spouse and dependent children in Canada, you can't even come to Canada. So there are many layers of problems right now.
Thank you. Me to call on you. Okay, so we'll start then, if we may, with Professor Davis for up to 10 minutes. Please proceed.
Well, thank you, Mr. Chair, and thank you to the committee for inviting me. I hope I'm heard okay. Okay, thank you. I should note, in addition to being a U.S. scholar nowadays, I spent 30 years in Hong Kong as a professor of constitutional law and human rights, and I continue to teach there. I'll be teaching 2 human rights courses via Zoom this fall, so I'm very much involved. I've been a public intellectual in Hong Kong throughout these many years. What I want to talk about, probably as the constitutional lawyer that's starting this testimony, is about the rule of law and the national security law that's now been imposed on Hong Kong. There's a number of questions in this law. The law itself seems to have a status as high as the basic law of Hong Kong. In fact, I would say it's higher, because under Chinese national law and legislation, the last law enacted, as is common in many countries, the last law enacted takes precedent over any conflicts with previous laws. So the basic law of Hong Kong is an older law, it's more general. The national security law is more specific. The way it was enacted already had imposed something on Hong Kong in a very offensive way. None of the law was leaked to the public until the day it was promulgated. We were told even the chief executive did not know what was in the law. So contrary to China's own laws, national law and legislation, and Hong Kong's practice, there was no consultation with the public. This law was just imposed on Hong Kong. The national security law, on its face, it says that it's superior to all local laws. And I would argue effectively that includes the basic law of Hong Kong, which is the foundation of rights protection in Hong Kong. The national security law says explicitly that, I guess you could say that the courts cannot really review it. It's not subject to constitutional review. It's not subject to review under the basic law. So if a judge receives this law in court, he has to pretty much apply it. And the National People's Congress Standing Committee has the ultimate power to interpret it. So that the idea that the courts would stand as a guardian to protect us is not there. In Hong Kong, and I can say I'm a resident of Hong Kong, so I refer to it as us, but in Hong Kong, we will have no opportunity to challenge some of the provisions in this law on subversion, sedition, on collusion with foreign governments, and so on, if this matter is brought to court. And then there's interesting twist in the law. It provides that only selected judges on a list can actually hear cases under the national security law. And the chief executive of Hong Kong is to construct that list. Now, if a judge is on that list and he hears cases, if he acts in or makes statements in any way that violate national security, then that judge will be dismissed from hearing such cases. Now, in Hong Kong, one of the ways that Hong Kong was to preserve the rule of law in the face of the mainland system, which really doesn't have the rule of law, was that foreign judges, including Canadian ones, sit on Hong Kong courts. Well, they will not be sitting on these national security cases because they will not be on the list of judges chosen by the chief executive of Hong Kong. So presumably the choice would be influenced by the expectation of how those judges would behave. Now, given all of this sort of pressure on judges, one would wonder what they would do if they're confronted with statements coming out of the foreign ministry in Beijing or coming from mainland officials now appointed in Hong Kong, saying what they think, how a case should be treated. Now, we don't have to guess at this. Just this week, Jimmy Lai, the publisher of the Apple Daily, was arrested. While the Hong Kong officials referred to him as a suspect, he was suspected of collusion, apparently because he provided funding for an organization, much like some of the organizations that are represented in testimony today, that lobby foreign governments. Usually Hong Kong oversees Hong Kong actors. So we don't know for sure because the enforcement of this law is done secretly. So we have a kind of secret police going on now. But presumably the word on the street, as it were, is that he funded an organization called Stand With Hong Kong. So we'll see if that proves to be the case. Interestingly, the foreign ministry immediately insulted him and said that he represented a great threat to security, national security in Hong Kong. I forget the precise words, but in any event, they almost prejudged the case. Now, how will a judge react to this? If legal issues come up, knowing that the NPC can override their interpretation, how will they respond to these statements by mainland officials condemning the defendant before he is tried? Now, the autonomy of Hong Kong is very important. The reason autonomy was given Hong Kong because the mainland system is very much at odds with the Hong Kong system. In Hong Kong, as in Canada, we have the rule of law. In the mainland system, the common characterization is rule by law, where officials sort of stand above the law and take great liberties in interpreting the law. Now, the autonomy is undermined in two ways. One is a local committee is created, headed by the chief executive, to oversee national security matters, and all national security matters are under this committee locally. She would oversee what police can do, and this committee has already issued regulations on how the police can behave, which enables searches without warrants. For one thing, there are judges, magistrates who can issue warrants, but those are not needed if the law enforcement officers feel that there's some kind of urgency where they could go ahead and search in advance. So this is one problem. And within the police now, there's a special unit on national security. And within the prosecution, there's also a special unit on national security. So all of this is well lined up. And this committee that oversees all of this in Hong Kong answers directly to the Central People's Government. So autonomy effectively goes out the window in this most sensitive area for Hong Kong's autonomy. Of course, national security is the most sensitive area. And then on top of that, there's a mainland office on the safeguarding of national security that's totally staffed with mainland officials. Now, why they need that, I don't know, because they've also placed an advisor in the local committee. So they have an advisor in the local committee that is to advise, but given that the central government is overriding the local committee, presumably that advisor can already supervise local actions. But there is a separate office, and the office is totally staffed with mainland officials and people from the state security and the public security branches on the mainland will staff that office, and neither the local committee nor that office are subject to review by the local courts. It expressly says in this law that the local committee is not subject to review, and it says that local courts have no jurisdiction over that so-called office for safeguarding national security. So Hong Kong's rule of law pretty much goes out the window here. And there's a long history in Hong Kong of mainland officials actually saying when courts in Hong Kong have exercised constitutional review, the mainland officials often say there's supposed to be no separation of powers in Hong Kong. So the idea of the court stepping up boldly and challenging what mainland officials say is going to be very difficult. So these are the kinds of problems that I thought worth highlighting here at the start of this hearing, because I'm sure a lot of the events that bear out my concerns have occurred, and I imagine other speakers will talk about them. It's interesting to me that mainland officials in this national office, this office set up in Hong Kong, may not even be subject to any law in a way, because under Hong Kong's basic law, only laws in the Annex 3 of the basic law apply in Hong Kong. So if a mainland official does something that violates mainland law, there will be no jurisdiction over him. And in the exercise of his duties, if he violates local law, there'll be no jurisdiction over him. So we have a kind of secret police who have no real control over them. And this, I think, and I'll close with this, for Hong Kong, these things are very important because these things are at the heart of why we have one country, two systems. The mainland officials can claim if they want that they're upholding one country, two systems, but the reality is that the one country, two systems was to be upheld by the institutions in Hong Kong, which were separate from the mainland systems. And that separation has been totally collapsed. There's a long essay I could write on human rights protections here as well, but my time is up and I'd be happy to entertain questions. Thank you.
Thank you very much, Professor Davis. And now we'll call upon Mr. Rogers from Hong Kong Watch. Mr. Rogers, please, for 10 minutes.
Thank you very much, Mr. Chair and committee. Can I just check that you can hear me? Great. Well, it's a privilege to have this opportunity to speak to you today at this critical time for Hong Kong, and I want to thank you for holding this hearing. Hong Kong has seen many dark days over the past 12 months, and Monday this week, as has already been mentioned, was among the darkest. The arrests not only of Jimmy Lai, but also Agnes Chow and other activists, and the raid of Apple Daily, the newspaper Apple Daily's newsroom by 200 police officers represents yet another brazen assault on Hong Kong's civil liberties and really the death knell for press freedom in particular. As has already been so ably outlined by the first witness, the imposition of this draconian national security law by the National People's Congress on the 1st of July essentially has destroyed Hong Kong's autonomy. It marks the end of one country, two systems. It's placed many activists in very grave danger, and it's a flagrant violation of the Sino-British Joint Declaration. And if you didn't already guess from my accent, I'm from the UK and speaking to you from the UK. And that, of course, is an international treaty that is lodged at the United Nations. And so for these reasons, and also due to the extraterritorial application of the new security law, which incidentally is worth saying, applies to people, whether they are Hong Kongers or not, whether they're inside Hong Kong or outside Hong Kong, and in effect means that meetings like the one we're holding now could be in violation of Hong Kong's security law. It represents an all-out assault, not only on Hong Kong's freedoms and way of life, but also on the international rules-based order. The subsequent disqualification of pro-democracy candidates for the Legislative Council's elections scheduled for September, and then the postponement for a year of those very elections, disenfranchises Hong Kong people and shuts down one of the few remaining avenues that they had for some level of freedom of expression. In effect, these events signify the total takeover of Hong Kong by the Chinese Communist Party system. As the Hong Kong Bar Association has said, the national security law undermines fundamental rights and liberties and the independence of the judiciary and the rule of law. Among the many human rights violations to highlight, the widespread, consistent, disproportionate and indiscriminate brutality by the Hong Kong police over the past 12 months in particular requires particular attention. A recent inquiry conducted by the British Parliament's all-party parliamentary group on Hong Kong into violations of human rights and humanitarian principles by the Hong Kong police force found in particular that, and I quote, humanitarian aid workers have been subjected to a variety of treatment that fell short of international humanitarian law and principles, international human rights, and the Sino-British Joint Declaration. The treatment of aid workers was subjected to, included intimidation, harassments, threats, physical violence, and arrests. The all-party group, in its recently published report titled "The Shrinking Safe Space for Humanitarian Aid Workers in Hong Kong," calls, among other steps, for the establishment of an independent mechanism to investigate the situation in Hong Kong, either through the United Nations Human Rights Council or General Assembly, or through a body such as the International Bar Association. It also calls for the imposition of Magnitsky sanctions on those responsible for permitting excessive police violence in Hong Kong, including, but not limited to, Chief Executive Carrie Lam and the Police Commissioner. Let me move on to some specific recommendations for Canada, and I do so with all humility. It's not for me to sit here in Britain and tell Canada what it should do, but these are suggestions that you might like to consider, perhaps together with my own country. I really welcome Canada's decision to suspend the extradition agreement with Hong Kong, but I believe that there is more that could and should be done. Firstly, I would encourage Canada to work with other like-minded countries to establish an international contact group to coordinate a global response to this crisis. This is an idea that's been put forward by 7 former British foreign secretaries. And of course, the early foundations for this have already been laid by the fact that your foreign minister has joined together with his counterparts from the UK, Australia, New Zealand, and the United States on several occasions in statements, and this is very welcome. But I think more could be done to solidify coordination among democratic nations to ensure that the response to this crisis is not simply rhetorical nor piecemeal, but is robust, rapid, unified, and as coordinated as possible. Secondly, I would encourage Canada to impose Magnitsky targeted sanctions on officials in the Hong Kong government and police force and the Chinese government responsible for human rights violations and for this breach of an international treaty. Such sanctions would be extremely helpful because they would be targeted. We don't advocate sanctions against China or Hong Kong or the people of those two places, but on individual officials directly responsible. And I believe that the Chinese regime does not respond to rhetoric or statements. The only language they understand is pressure, and targeted sanctions would send a clear signal that they would not be allowed to get away with what they've done with impunity. Thirdly, I would encourage Canada to publicly support calls for the establishment of a UN Special Envoy and a UN Special Rapporteur on human rights in Hong Kong, a proposal advocated by at least 50 current UN Special Rapporteurs, several former rapporteurs, the former UN High Commissioner for Human Rights, the last Governor of Hong Kong, Lord Patton, and indeed the chairs of the Foreign Affairs Committees of your own Parliament, together with the Parliaments of Australia, New Zealand, and the UK, shining a spotlight on Hong Kong through a monitoring and reporting mechanism at the UN would be very important in ensuring that human rights violations are not perpetrated with impunity. And finally, I would urge Canada to, again, work with other countries to coordinate a lifeboat rescue package to ensure that those who do need to escape from Hong Kong are offered sanctuary and an opportunity to seek citizenship in the free world. This should only be a last resort. The objective should be to exert pressure to prevent Hong Kong deteriorating further into a situation where people need to flee. But the reality is that it is already at an extremely dangerous point. Some activists have already fled the city, and more Hong Kongers will do so in the months and years ahead, either because they are in real danger or simply because they see no future in a city that is stripped of its freedoms. The United Kingdom, as I'm sure you're aware, has made a very generous offer to Hong Kong's British national overseas passport holders, which is very welcome. But it leaves many of Hong Kong's young people, especially frontline activists, unprotected because nobody born after 1997 qualifies. Canada could help address this need in various ways. So I just close by raising the question, why should any of this concern Canada? And I would say for three reasons. Firstly, because of your history, and you don't need me to tell you about that. Secondly, because you are a country that prides itself on the defense of freedom and human rights. And thirdly, because the Sino-British Joint Declaration is not only an agreement between Britain and China, but it is an international treaty that concerns all of us who believe in the international rules-based system. I believe the time has come for the free world to act in defense of freedom, democracy, and human rights and the international rules-based order. And that action should be as strong, targeted, and united as possible. Thank you very much.
Thank you very much, Mr. Rogers. And we'll now hear from the Toronto Association for Democracy in China. Will it be Ms. Go or Mr. Kwan first?
I will go first, Mr. Kwan.
Please go ahead.
On behalf of the Toronto Association for Democracy in China, I wish to thank the committee for this series of hearings on the situation in Hong Kong. For too long, we believed that China will abide by international rules of engagement and diplomatic civility, as well as the respect for the fundamental concepts of rule of law. This illusion has now been shattered by the arbitrary arrest of the two Michaels and the retroactive application of the national security law in Hong Kong. For this presentation, we will focus on two areas that we, as Canadians, can undertake. First, how to counter China's interventions and interference and protect our Canadian interests and values. Second, what specific programs Canada should adopt to support those in Hong Kong who try to leave. I will address the first, and my colleague Avvy will address the second issue. Since Tiananmen Square massacre in 1989, China has made a concerted effort to mask its human rights abuses and to present a positive image to advance its global ambition. It has set up hundreds of proxy associations in Canada, many of them empty shells, to influence and interfere in Canadian political, social, and cultural spheres, and to gain access and to influence our elected officials. Here are 4 examples of this united front strategy that Chinese consulates and their proxies have carried out. They have held community press conferences to support the release of Meng Wanzhou and more clumsily hire non-ethnic Chinese actors to demonstrate in order to show the mainstream support for their cause. They have compelled Chinese international students to demonstrate against pro-Hong Kong rallies by threatening to withhold their government scholarship or harming their families back home if they don't comply. They cultivated the mayor of a rural British Columbia community for years so that his quote praising China's response on COVID-19 is used on Twitter to burnish China's virus fighting narrative. And finally, they introduced the Confucius Institute, which CSIS has deemed to be a quasi-spying agency, into an Ontario school board by hosting a reception for his chair at Beijing's Great Hall of the People, a venue normally reserved for heads of state. And this wholesale and ongoing influence in our civil society has continued for 30 years as part of China's effort to influence our policies and politics. To dampen or to put a stop on this effort, we should be vigilant against cyber attacks and theft of intellectual property from our corporations and research institutions. 2, provide critical assessment of China's takeover of our corporations in strategic industries such as mining and energy resources, as well as institutions vital to our national security, such as infrastructure and nursing homes. 3, support a national hotline as proposed by Amnesty International to coordinate and to encourage the reporting of China's harassment and intimidation of our own citizens. 4, establish a more stringent process to ensure transparency among current and former elected officials in their relationships with China in order to mitigate undue foreign influence in our internal affairs. 5, coordinate with like-minded allies and join the call for a UN Special Rapporteur on Hong Kong. 6, apply the Magnitsky Act to sanction officials from Hong Kong and China responsible for human rights violations. Finally, this was not in my original script, but I want to share with you a news report that just came in yesterday about the recent global affairs contract to award a Chinese company to install and maintain X-ray scanners in our embassies around the world. Not only did 2 other Canadian companies offer lower bids, but that the Chinese company, Nuntech, was slapped with a 5-year tariff by the EU for alleged dumping and engaging in questionable practices. And recently, the company has been caught setting up a honey trap to scheme a Taiwanese official into purchasing these machines. I will now yield my time to my colleague, Avvy Go.
Thank you, Cheuk, and thank you, Chair. Thank you very much for having us this afternoon. As mentioned before, apart from being a director of TADC, I'm also a lawyer and the clinic director of the Chinese and Southeast Asian Legal Clinic, where we provide free legal services to low-income clients, including many refugees from China. But as we speak, the crackdown on pro-democracy activists in Hong Kong is happening right before our eyes. The arrest of Jimmy Lai confirms that no amount of fame and fortune can protect anyone who dares speak out against China's dictatorial regime. But with over 300,000 Canadians living in Hong Kong and several hundreds of thousands more so Canadians of Hong Kong origin living in Canada, the Canadian government not only have a moral duty to act, but a legal obligation to protect our citizens and their close family members in Hong Kong. Since the Second World War, there have been many examples of Canada granting status to large groups of people fleeing political persecution and civil war. And while the flame of democracy is being suppressed, Hong Kong is burning. And although we may not be able to extinguish the raging fire, we must do what we can to contain its damage and save as many lives as possible. So to that end, we're calling on Canada to take the following actions. First, Canada should expedite family sponsorship applications by Canadians for their families in Hong Kong, including spousal sponsorship as well as sponsorship for parents and grandparents. And Canada should also expand the family class program to facilitate reunification of Canadians with other family members in Hong Kong. Second, as soon as the travel ban is lifted, Canada should issue more temporary resident permits or work visas to Hong Kongers, as well as student visas to young people who want to continue to pursue the study in a safe environment. Third, we should create a special program to grant permanent resident status to the Hong Kong activists involved in the pro-democracy movement and who are already in Canada. Similar to the special program created for the thousands of Chinese nationals present in Canada after the 1989 Tiananmen Square massacre. And finally, for those activists who have been arrested or are in imminent danger of arrest, we should direct the Canadian consulate in Hong Kong to issue temporary resident as well as travel document to facilitate their safe and immediate exit from Hong Kong should they choose to leave. Upon their arrival in Canada, we should provide them with protected person status or permanent resident status. Hong Kong people have stood up against the powerful authoritarian regime to safeguard the core values of democracy and freedom of expression. It's incumbent upon all of us as Canadians to provide our meaningful support. Thank you.
China Report.